We're back with our second podcast with Duncan Inverarity from Irish law firm A&L Goodbody. And today we're speaking about the end of employment.
Thanks, Ailey, and hi again, Duncan. So, Duncan, I wanted to start, please. We're talking about firing people in this podcast, and I want to start by talking about sort of what protections against dismissal employees enjoy in Ireland that employers will need to be aware about.
Yeah, I think a fundamental difference between the UK and Ireland in terms of employment rights on the termination of employment is the employment injunction. I'll come back to that in a minute. We have very similar laws to you, although there are differences, which I'm sure we can explore, insofar as the unfair dismissal regime is concerned. But we have a statutory regime protecting people from unfair dismissal. So in Ireland, any dismissal is unfair unless it is based on conduct, capability, competence, redundancy, or some other substantial reason. So if it doesn't fit into those categories, it is an unfair dismissal. Those categories are very broad, and I think you'd be hard pressed not to think of a termination that doesn't come within those specific confines. So if you can establish that, it's not an unfair dismissal. But the onus is going to be on the employer to prove that it wasn't an unfair dismissal. So apologies for the double negative, but what that means is all dismissals are presumed to be unfair until the employer can prove otherwise. Now, the only exception with that is constructive dismissal, which is where an employee, because of the conduct of their employer, says, I'm not taking this anymore and will resign. So the onus is on the employee in that circumstance to prove that they had to do what they did. So let's put unfair dismissal aside for a moment, which would be the majority of, which would be the significant jurisdiction for dealing with terminations. There is also provision in our Industrial Relations Act for an employee to take a trade dispute to the Workplace Relations Commission in circumstances where they have a trade dispute. And the definition of a trade dispute is broad enough to encompass an unfair dismissal or a termination of employment. The only employees who would take that course are employees who have less than the requisite 12-month service, which is what is required to bring an unfair dismissal claim under the legislation. The third aspect that employees can bring is a discrimination claim on the basis that they have been terminated for a discriminatory reason. That is also available to employees, but cannot be run in parallel with an unfair dismissal claim. Then the final aspect, which is the most significant difference between ourselves and the UK, is the employment injunction, which I referred to earlier. So in Ireland, we have a constitutional right to natural justice and fair procedure. And in circumstances where I, as an employee, am of the view that that's been denied, then I am entitled to apply to the High Court for an employment injunction. Now, employment injunctions are incredibly expensive, both for employees and employers. They're very high stake, they're very high risk. So unlike our other jurisdictions, the traditional employment jurisdictions, in the High Court, costs will follow the event. So if an employee takes an employment injunction and they lose, ultimately, or in fact lose their initial application, they may be faced with a significant costs bill. And there is a wealth of jurisprudence around the employment injunction and what an employee must satisfy in order to obtain an employment injunction. But without getting into that level of detail, it's really important for people to understand, for employers to understand, that if you truncate your process, if you do not afford the employee natural justice or due process, there is a chance that they will take an employment injunction. And just the taking of an employment injunction is very public, no doubt would make the media, and very costly. So it's something which is a fundamental difference between ourselves and the UK that employers need to be aware of.
Yeah, that is quite different. Well, very different, and certainly not something that would happen here. And obviously, definitely something to bear in mind when you're kind of going through that process. Then, and you mentioned there that the bringing a trade dispute claim, and that's again something that we don't have, but we do obviously have the 2 year, well, so to bring an unfair dismissal claim in a similar way in the UK, you need to have 2 years service to get the protection from that, and the compensation for that is capped at 1 year's salary or around £90,000, whichever is lower. Because of that cap, we often see employees bring discrimination claims to maximise their potential compensation, because there is no cap where a discrimination claim is tagged onto an unfair dismissal claim or is separate. Do you see that in Ireland then? Do you have the kind of employees bringing discrimination claims, I suppose, with a view to taking the cap off their compensation?
Yeah, it's again an interesting difference between the two jurisdictions. So the unfair dismissal regime is a year's service, so you only need a year's service to access the Unfair Dismissal Act, and the redress, apart from the normal reinstatement redress, is remuneration based on an assessment of a 2-year cap. So it's not £90,000 or an equivalent, it is a 2-year cap of remuneration. So if you are, certainly there's been awards made by the Workplace Relations Commission of 2 years salary for an employee who was on 650,000. So it was a 1.3 million award. So you have with the greatest respect, reasonably low level employment forum making awards of 1.3 million euro. So technically any employee, whether you are working in the car park or the chief executive officer, you can take a claim under the Unfair Dismissal Act, and the cap is 2 years remuneration. So we don't see that phenomenon that you're seeing in the UK, because the discrimination legislation would produce a similar result. The fundamental difference between a discrimination claim and the unfair dismissal jurisdiction, apart from one's discrimination and one's unfair dismissal, is the fact that under unfair dismissal, you have a duty to mitigate. So while the cap is 2 years, in fairness, it's rare that an employee is awarded 2 years salary unless the adjudication officer or the Labour Court take a particular view on the conduct of an employer, although there is no power to issue punitive damages. It's more the fact that they make an assessment based on the conduct of the employer up to 2 years remuneration. But you do have a duty to mitigate. So that is to try and obtain alternative employment, or at least be seen to be obtaining alternative employment. And in this day and age in Ireland, I don't know what it's like in the UK, employment is reasonably buoyant. So there would be a reasonable expectation that employees at the moment would be able to obtain alternative employment. So that's the difference between the two actions, but the cap is by and large the same.
Yeah, and that's quite an interesting point of difference, I suppose, between the UK and Ireland here. In the UK, largely for all of our claims, it's based on compensation for loss of salary with a duty to mitigate, and that applies whether it's a capped claim like unfair dismissal, or an uncapped claim like discrimination, or whistleblowing, which is whistleblowing in the UK is treated as a form of unfair dismissal or detriment claim, but without a cap like discrimination. There is also a sort of modest injury to feelings potential, but the duty to mitigate applies for the damages section of any of those claims. And
yeah,
certainly we see.
Sorry, I was going to say it's interesting. We don't have the injury to feelings claim. And sorry, remiss of me not to mention the Protected Disclosures Act. We do have a protected disclosures regime, which, insofar as termination is concerned, is considered to be an unfair dismissal, and we have up to 5 years remuneration in the event that someone is terminated for making a protected disclosure. That said, we haven't had any awards to that level, and there are rights that people have in the event that they take a claim, a successful claim under the protected disclosure regime, which would include obtaining an employment injunction in circumstances which don't require you to go to the High Court. It would be in the Circuit Court, and a more efficient way of dealing with an employment injunction. So you're right, Adam, we do have a similar regime in Ireland under the Protected Disclosures Act.
Yeah, and actually the whistleblowing regime in the UK is one of the rare examples where there is a form of employment injunction. related to dismissal. It's not widely known by claimants, but there is potential to bring a form of employment injunction to preserve employment pending a full employment tribunal claim if it's a dismissal related to whistleblowing status. Very rarely run by claimants because there isn't great awareness of it, but that is a rare example of that in the UK.
Yeah.
And so having talked this all through, I suppose, if an employer has a cause termination situation, someone who's committed what appears to be gross misconduct, what steps are you looking at in Ireland to try to sort of avoid this injunction route, avoid whatever type of claim they might bring? What would good look like in terms of a process for dismissal?
Yeah, that's a complex, it's an easy question with a complex answer is probably the best way to approach that. In very general terms, an employer has to follow due process. What does that mean? Well, due process is essentially set out by the employer in their policy, in terms of their disciplinary policy, and they have to go through that process. If they don't, there is going to be a fundamental problem insofar as the process that you have applied may not be fit for purpose and gives rise to the unfair dismissal claim. There is also the requirement to go through, as I've said, and satisfy an employee's constitutional rights. And that overlaps with due process, there's no doubt about that, but it touches on things like allowing the employee to inform the employee precisely of what the allegations are, to give the employee the right to respond to those allegations, the right to representation, which is a big question. And what does that mean? It means that they are entitled to be represented by a trade union official or another work colleague, but no one unconnected with the business. So what does that mean? Lawyers. There has been recent jurisprudence to suggest that lawyers, it's not a standard requirement that lawyers be present at a disciplinary hearing, but it still leaves open the door that in exceptional circumstances, it is appropriate that a lawyer to be there. But the case that I'm talking about involved a sort of alleged criminal behavior of an employee, reasonably complex case, but the Supreme Court still held, which is our highest court, still held that did not constitute exceptional circumstances. So they have to be really exceptional circumstances for a lawyer as of right to be there. And, maybe in circumstances where it's not just your employment you're losing, but it's your vocation. So I'm thinking of, say, regulated employees, to include financial services, but to include, say, the medical profession, to include nurses, people who are lawyers, perhaps, who are regulated, where if you are found to be in the wrong, you not only lose your employment, but you may lose your vocation. So perhaps in those sort of circumstances. So I digress slightly. Other constitutional rights are the right to confront your accuser, which is the right to cross-examine. Again, somewhat misunderstood, really only directed to where there is conflicts of evidence. You can't, so for example, if you have a bullying and harassment, it's almost an anathema to allow the person who's accused of bullying an individual to come in and cross-examine that individual. So it is a complex and sensitive area that you need to look at. But there's some of the constitutional rights that employees have. And when they do have legal representation, you can be rest assured that they will be insisting on all of those rights.
That's interesting. I think similar in the UK in terms of who employees have a right to be accompanied by. But yeah, very similar approach. And then obviously separate to the kind of the statutory and the constitutional kind of requirements of the process. Obviously, you're aware in the UK, an employer has to dismiss in accordance with the contract, and employers, we often see contracts give employers the right to place employees on garden leave or pay in lieu of notice, and some jurisdictions don't have those rights. I think you do in Ireland. Is that fair to say? Is there any differences with those terms?
Yeah. So one other, just touching on that point, Ailey, is the right to terminate simply by giving notice. So employment contract, as in the UK, is a contract between an employer and employee that can be terminated by giving notice. And there is no problem in doing that. So I can simply walk into an employee and say, I'm terminating you without cause by giving you notice under your contract or the statute, whatever is more beneficial to the employee. And that's available to me. The downside of that is that it is an absolute slam dunk unfair dismissal, because I'm not dismissing them for conduct, capacity, competency, redundancy, and so on. I am just dismissing them in accordance with the terms of the contract. So it is an unfair dismissal almost by definition. So there is the right to do that. Insofar as garden leave is concerned, absolutely. You can put employees on garden leave if it's provided for in the contract. And similarly, you can pay in lieu of notice if it's provided for in the contract. So the contract is the answer to that issue, but it's certainly something which is available. Although I always find garden leave in the Northern Hemisphere is not nearly as attractive as garden leave in the Southern Hemisphere. Much warmer down there.
So, Duncan, one other thing just to touch on very briefly was any sort of special protections that apply from dismissal. So I'm thinking in the UK that there are special rules that apply for people who are pregnant. There are special rules apply for people who are trade union officials, things like that. Presumably you have sort of similar concepts in Ireland as well.
Yeah, and we do. So employees who are on maternity leave cannot be terminated while they're on maternity leave. So they are protected, and the termination, or any termination which is meant to take effect while they're on maternity leave, is just null and void and cannot take effect until the person returns from maternity leave, which raises issues for those employees. So, for example, if they're made redundant, their redundancy cannot take effect till they get back from maternity leave. But if there is a payment on offer for an employee, they may want to take it sooner rather than later and not wait till they return from maternity leave. So you will find employees sort of almost artificially coming back from maternity leave early in order to access a severance payment. But by and large, you cannot terminate an employee on maternity leave. You can't terminate employees, as you said, trade union officials, or if they're terminated because of their trade union activity. Again, that's very, very rarely used. Employees are too savvy to do that. They don't tend to do that. So it really is the majority of cases involving protected employees are those who are on maternity leave.
That's interesting, because actually in the UK you can terminate somebody on maternity leave, but obviously there's more risk around it. But you could make somebody redundant; they would just maybe have certain entitlements to continued pay. But that's an interesting difference. Then finally, so just covering kind of practical steps that employers should be thinking about when they're trying to resolve termination disputes in Ireland. Is there any specific things that employers should be thinking about? Like, for example, and I assume that you can offer a severance package in return for employee waiving their claims under a settlement agreement.
Yeah, absolutely. A fundamental difference with the UK, though, which a lot of UK employers are not aware of, is this concept that you have that we don't, of protected discussions. So an employer cannot have a protected discussion with an employee unless they involve either in-house counsel or their external lawyer. So the more traditional approach, shall we say, to those types of discussions, where a truly without prejudice discussion has to occur between lawyers for it to maintain that element of, to maintain the without prejudice nature of that discussion. So you can't, as an employee, go and say to an employee, look, we can go through a very difficult process, or let's come to a deal, because that conversation can be used in subsequent proceedings. And if that conversation happens, it would be pretty much a prejudgment of the outcome of any procedure that had to be gone through by way of a disciplinary procedure or otherwise. So again, that's a fundamental difference with the UK. That said, these issues often end in severance payments being made and severance agreements being signed up where employees waive their rights. Again, a difference with the UK is that you have to have legal advice or a certificate from a legal advisor with your severance arrangements, whereas in Ireland you don't. But the jurisprudence is very much along the lines of if the employee is not advised of what they're in fact giving up and signing away, then it's probably not worth the paper it's written on. Now, that includes lawyers, clearly, but also trade union officials. So you need someone who is aware of what the employee is giving up in order to advise them properly. And as I say, that really is lawyers and trade union officials. But severance payments are fairly common. If you go down to the Workplace Relations Commission, I'd say probably 80% of cases would resolve either at the Workplace Relations Commission or prior to by way of severance payments.
Perfect, thank you. So that wraps up our second podcast in this set, and please join us in the next one where we'll be covering other key employment law topics in Ireland.